All right, good morning, everyone, and welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us this morning. The Data Practices Office is a small office in the Department of Administration, and we are a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions about those laws from members of the public and government. If you have questions about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you register. We also record our webinars and post them on the Data Practices Office YouTube page. So if you missed part of today's webinar or want to go back and watch it again or find one of our previous webinars, you can do so on that YouTube page. If you'd like to download a copy of the PowerPoint right now, I will share a file for you to download and save to your computer. One moment here as I pull it up. Okay, that file, that pop-up window should appear for you to download the file. If this doesn't work for you, you can certainly visit the webinar webpage on our website where you registered and scroll down to the bottom of that page to find this presentation. A copy of the slides should be available under the Data Practices Potpourri Webinars toggle near the bottom of the page. I know that a lot of folks have problems with this file transfer system. So again, if you can't download it from there, go ahead and find that on the webinar page on our website. Okay, today's webinar is another installment of Data Practices Potpourri, where we highlight questions we've received from data requesters and government entities. We will leave some time for a Q&A session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send in your questions so we can be sure to see them. You can start sending the questions now, or you can wait until the end of the presentation. The first question up is about data access policies. As a quick reminder, Section 13.025 does require all government entities to have a data access policy for members of the public that describes how someone can make data requests and access public data. The section also requires an access policy for data subjects describing the rights of data subjects as well as the processes to request public and private data about themselves. So, a government entity recently asked our office about whether the Data Practices Act required its governing body, in this case a city council, to formally approve the data access policies that must be created under Section 13.025. There's no language in the Data Practices Act that requires a governing body to formally approve data access policies. In fact, for many government entities, such as state agencies, there may not even be a governing body that would be available to formally approve the required policies. Rather, Section 13.025, subdivisions 2 and 3, specifically state that the responsible authority shall prepare the respective policies. So the duty to create these policies ultimately falls to the entity's responsible authority. Of course, government entities have different processes to establish and implement policies, and some may want to follow a process where the governing body ultimately approves the data access policies for implementation. There's no language in the Data Practices Act that prohibits a government entity from following this type of governing body approval process, and we'd largely defer to each entity for how it wants to formally approve and implement its data access policies, so long as the policies exist and are available to the public. As a reminder, government entities must annually review and update the data access policies by August 1st. So if your entity does have a process that requires the governing body to approve the policies for implementation, you'll want to make sure that your entity builds in processes to meet this requirement. I know that some entities may have a governing body review the policy at a July meeting prior to the August 1st deadline. And I've heard other entities including the review and approval of the policies during the first organizing meeting of the year in January. Either process would work so long as the review and updates occur each year. The next question we have is one that we see occasionally come up throughout the year. Specifically, folks have asked about the classification of different types of taxpayer ID numbers, such as a state taxpayer identification number or a federal employer identification number. Essentially, these are numbers that the Minnesota Department of Revenue and the IRS assign to businesses so that businesses can report and pay their various taxes. And the government entity may have these numbers as the result of the day to day work it does with a variety of different businesses. So, we often get questions about the classification of these numbers when an entity is responding to data requests for various contracts or other types of financial records. So, the very high level answer to this question is that these types of taxpayer identification numbers are going to be public data in the hands of most government entities. However, there are several notable exceptions that I need to highlight when these numbers would be classified as not public data. Specifically, federal law prohibits government entities from redisclosing a federal employer identification number when the entity receives the number directly from the IRS. So, if your entity received records containing tax return information from the IRS, your entity should not redisclose those data. Additionally, Section 13.591, subdivisions 1 and 2, classify income tax returns as private or non-public data when a business requests financial assistance or a benefit financed by public funds from a government entity. Meanwhile, Section 13.204 classifies tax return data submitted to political subdivisions in order to obtain a license as private or non-public data. So, if the only location where your entity has these taxpayer identification numbers is in tax returns that folks submit under either of these processes, then the numbers would be classified as not public data and should not be disclosed to a public data requester. And I also just want to remind everyone that Social Security numbers are classified as private data under Section 13.355, and you should be redacting those when responding to data requests from members of the public. All that said, there are some other considerations that exist when it comes to these types of taxpayer numbers, and we'd be here for a while if I continued to highlight them all. However, the Data Practices Office website does have a new page that walks through many of these considerations. That information is available via the link on this slide, and I would encourage you to review that webpage for additional information. I'll pause for just a moment to allow folks to copy that link down, but you can also find it by downloading the slides from our webinar page. Okay, moving on to our third question today, which involves video data that were captured by security cameras in the lobby of a government building. The question posed to us was, what is the classification of these types of video data? So there's no section within the Data Practices Act that specifically addresses general security camera footage and data. As a result, these types of data are usually presumptively public. That said, these video data could be pulled into other classifications within the Data Practices Act depending on the context. For example, if a security camera captured video of a dispute between employees that led to an HR complaint, it's possible that a copy of that video data may be personnel data as part of a disciplinary investigation. As a result, that copy of video data would be governed as personnel data under Section 13.43 and could potentially be classified as private data. We've also spoken with government entities that have received data requests for security camera footage from secure locations, such as jail facilities. In those situations, an entity may designate those data as security information under Section 13.37. Of course, an entity should be applying this designation on a case-by-case basis when disclosure of the video data would likely jeopardize safety or cause some type of harm as described in Section 13.37, Subdivision 1A. However, it's another section that comes up on occasion when there is a request for video data created by security cameras. In short, security camera footage of general publicly accessible areas are typically public data unless there's additional context that would cause a different section of the Data Practices Act to apply. Of course, if there are unusual scenarios that come up, feel free to reach out to our office. We'd be happy to discuss these considerations further. We've received quite a few questions recently about the new language in Section 13.825, Subdivision 4, which requires law enforcement agencies to disclose copies of unredacted body camera data related to collision investigations. Specifically, some of the questions we've received are related to who can obtain a copy of unredacted body camera data. For example, does the new language allow anyone who could be seen or heard in the body camera data to get an unredacted copy of the video? Okay, the short answer here is that access to unredacted copies of body camera data related to collision investigations is limited to only the individuals who are eligible to obtain a state accident report. Specifically, the language of Section 13.825, Subdivision 4C, states a person entitled to a report of a collision under Section 169.09, Subdivision 13, must be provided with unredacted copies of body camera data used in the collision investigation. In other words, only the individuals who are identified in Section 169.09, Subdivision 13, can get a copy of the unredacted body camera data related to a collision investigation. So let's turn to who those folks are. Okay, looking at Section 169.09, Subdivision 13, the following individuals are entitled to copies of a state accident report and, by way of 13.825, Subdivision 4C, a copy of unredacted body camera data related to the accident. First, any individual who was involved in the accident. If the accident resulted in someone's death, then the representative of the deceased's estate, the surviving spouse, one or more surviving next of kin, or a trustee appointed to pursue a legal action related to a wrongful death may access the report. Second, any other individual who was injured in person, property, or means of support, or any other person who was financially harmed as a result of the accident can get a report. For example, if a vehicle crashes into a house, the homeowner would be able to get a copy of the state accident report. Additionally, both the attorneys and insurance companies for the various folks described in the first two categories can also get copies of the state accident report. And finally, a prosecutor or attorney who is representing the state in an implied consent hearing can obtain state accident reports. So these are all the different categories of people who are eligible to obtain a state accident report, and as a result, these individuals can also obtain copies of unredacted body camera data documenting a collision investigation. So that's really a long way to essentially say that if an individual cannot obtain a copy of the state accident report, then that individual would not be able to obtain a copy of the unredacted body camera data related to the accident. As a reminder, a request for unredacted body camera data under Section 13.825, Subdivision 4C, must be in writing and include a copy of the applicable state accident report. I can offer up a couple examples when Section 13.825, Subdivision 4C, cannot be used. First, there's an accident that a law enforcement agency responds to, but the damage is minimal and no state accident report is created. Here, there's no one who can obtain a state accident report documenting the incident, and any involved parties cannot meet the requirements to submit the report as part of their request for unredacted copies of body camera data. So, no copies of unredacted body camera data should be disclosed. Another situation may be an incident where someone merely witnesses a car accident but is not involved in any other way. An officer then interviews the witness with a body camera running. That witness cannot obtain a copy of unredacted body camera data related to the collision investigation because the witness is not one of the individuals who can obtain a copy of the state accident report. Of course, the data subjects in both examples can still access body camera data through the mechanisms of Section 13.825, Subdivision 4B, which means they can inspect portions of unredacted body camera data or obtain a redacted copy of the data where they can be seen or heard once any criminal investigation becomes inactive. However, these individuals cannot obtain unredacted copies of body camera data under Section 13.825, Subdivision 4C. For our fifth question, I just want to highlight an issue that I've been having a lot of conversations about. At the beginning of July, the Data Practices Office sent letters to law enforcement agencies identified on the Department of Public Safety's website as operating automated license plate readers. As a result, I've been chatting with a lot of different law enforcement agencies about the requirements of Section 13.824 and what they should do in response to the letter. As a reminder, Section 13.824, Subdivision 6 requires any law enforcement agency operating an automated license plate reader to complete an independent biennial audit of the ALPR system. The audit must review whether data in the ALPR system are appropriately classified, how data are used, whether data are destroyed according to the requirements of Section 13.824, and to verify compliance with authorization and data access requirements. The results of the audit are public data, and the law enforcement agency must send a report summarizing the audit to the chairs and ranking members of the committees of the Minnesota House of Representatives and Senate that oversee data practices and public safety issues, to the Legislative Commission on Data Practices, and to the Data Practices Office, which we receive on behalf of the Commissioner of Administration. Our office is then tasked with reviewing the summary to ensure agencies are substantially complying with the requirements of the law. If an agency is not complying with the requirements of Section 13.824, the Commissioner of Administration does have authority to order a suspension of an ALPR program until the agency demonstrates it can comply. So, if your agency is operating an ALPR system, it should be scheduling and completing an audit every 2 years to ensure compliance with the requirements of Section 13.824, Subdivision 6. Once that audit is completed, be sure that the summary report is shared with the applicable officials as required by the law. If your agency is just now implementing an ALPR system, then your agency will need to complete the biennial audit within the next 2 years and on an ongoing basis thereafter. Of course, you can feel free to reach out to our office if you have additional questions about the data practices requirements related to automated license plate readers. Okay, we'll wrap our questions with one about the open meeting law. We've recently had a public body contact us to explain that it was intending to hold a special meeting and asked whether its members could add items or topics to its agenda during that special meeting. The short answer here, no. Public bodies cannot add items or topics to an agenda during a special meeting if those items and topics were not identified in the purpose of the special meeting notice. Specifically, Section 13D.04, Subdivision 2, requires public bodies to post a written notice of any special meetings, and the notice must include the date, time, place, and purpose of the special meeting. In previous advisory opinions, the commissioner noted that for a special meeting notice to be effective, the body must provide sufficient details about the meeting's purpose, which is the intended object or end to be achieved during the special meeting. Other advisory opinions have explained that when a public body holds a special meeting, its actions are limited to those topics included in the notice of the special meeting. If a public body did not include a specific topic that it would discuss in the special meeting notice, then it cannot add that topic to the agenda during the special meeting. Essentially, a public body must properly notice all issues and topics it plans to address during the special meeting so members of the public can reasonably determine whether to attend that special meeting. So, if an issue does come up that the public body wants to discuss, but that issue was not noticed, then the public body must wait until its next regular meeting, repost the special meeting notice with the additional topics at least 3 days in advance of the special meeting, or notice a new special meeting in order to discuss those additional topics. As a point of reference, Advisory Opinion 23-003 provides guidance on special meeting notices, and a public body being limited to the topics that were described in the notice. And you can review that opinion for a deeper dive into the open meeting law's limitations related to special meetings. Okay, I'm going to pull a Columbo here and say just one more thing. Our office is in the process of updating Minnesota Rules, Chapter 1205, which are the administrative rules that implement the Data Practices Act. As a note of context, the current rules were adopted more than 40 years ago, and data practices work looks a little bit different today than it did in the early 1980s. So, as part of this process, we've created an informal draft of changes that we'd like to propose to the rules. However, we're hoping to get some initial feedback on these drafts, as well as other suggestions for how to update and clarify the rules before initiating the formal rulemaking process. You can find copies of DPO's proposed changes on our website, and you'll want to click the rulemaking link on the bar that runs across the top of the page to find those drafts. Those web pages also have more information about the rulemaking process in general. We are asking folks to email us any comments that they may have by October 10th, 2025. So there's still a bit of time to take a look if you're interested. But again, to be clear, this is not the formal comment period as part of the rulemaking process. We plan to initiate that process sometime after this initial informal review, and we'll be sure to communicate when the formal process opens. Okay, now we'll take some time to answer your questions. Remember to send them to all panelists so we can make sure that we see them. And just a few reminders on this slide that the slide deck is available on our website, and you can access the recording on our YouTube page within the next day or two. I'm also going to put an evaluation in the polling panel here shortly. If you'd please fill that out and let us know how we did and what other topics you'd like to see in the future, that would be much appreciated. We want to make sure that these webinars are useful to you, so thank you in advance for any feedback. And so I will pause there and we will open it up to the Q&A.
Thanks, Casey. All right, I can kick it off with our first question. Let me just mark it answered so you can all see it. What is a good statute to provide to someone who is asking for unredacted body-worn camera footage for a public data request? So just to take a step back, Minnesota Statutes 13.03 subdivision 3F does state that if an entity is withholding data in response to a data request, they do need to provide a citation that they're relying on to withhold that data. So you have to point to a citation that is classifying your data in such a way that that public data requester cannot see the data. So for a statute to look for if you are withholding access to body-worn camera footage, I would look to Minnesota Statutes 13.825. That is the statute that deals with body-worn camera footage. And specifically, subdivision 2A states that body-worn camera footage are classified as private or non-public data if inactive, but if they are part of an active investigation, then they are classified under Minnesota Statutes 13.82 subdivision 7 as confidential or protected non-public. So there is not a requirement for you to cite to a particular subdivision within that statute. I think citing to 13.825 is sufficient for a response for public data requesters. Just also be aware that there are some language in 13.825 subdivision 2 that does state that there is some body-worn camera footage that is public. So if it's not that public footage, then it will be classified as private, non-public if inactive, and you can point to 13.825 for that classification when withholding it. Hope that helps.
Okay, the next question is, if a unique data set is created using public information from different public sources, is that unique data set considered public data? So I can answer generally and say if you're making data from public data, it probably is just going to be public. That said, I would leave some room to say context is important. I can't think of a circumstance that would make it not public, but again, you're going to want to look at the context in which the data were compiled or put together. So generally just public, but would be open to hearing about any contexts that make you think that it would become not public, because that would be important to know. Thanks.
Okay, our next question asks, where can we go to look at policies from other agencies? So for a first general resource, I would say if you go to the DPO website and then you look at our resources tab at the top, we have a model policies section, and there we have model access policies and examples of data inventories and your policy on ensuring access to not public data. And then as far as other agencies go, if you have a particular agency in mind that you're curious what their policy says, usually how I find them is if you go to the agency's website and you scroll down to the bottom, you can usually find something that says data access or data requests or public records requests. And then if you go to that page where people can actually find out about submitting data requests, that's usually where these agencies will have their policies listed.
Okay, the next one is mine, and I think there were a couple of these, which is about the question, related to the language in 13825 connected to the state accident report. The question is, if no state accident report is written and only information exchanged between the parties at the scene, can they get the unredacted body camera footage? No, there has to be the state accident report or state crash report that's required by 16909 subdivision 8, which is one that the officers would fill out and submit to DPS. If that report is not created, then they do not get access under this new provision. So they need to have that report in order to get access to the unredacted body camera footage and get those copies. So there must be that report and they must have a copy of it in order to request and get access.
Okay, I can hop to the next question here. A relative has requested the personnel record for a deceased employee. What statute would this data request fall under? So data on your employees that you're maintaining because they were an employee of your entity would be classified under Minnesota statutes 13.43. And under that personnel data provision, most of the data you have about that employee, that former employee, would be classified as private. And then we look to Minnesota statutes 13.10, which sort of lays out access and classification on data on individuals who are deceased. And so I will just hop to that language right here. And really what that data on decedents provision says is that that private data that you had of that employee becomes a private data on decedents is what the statute calls it. And someone who is the representative of the decedent has access rights to this private data. The representative of the decedent is the personal representative of the estate during that period of administration. And if they don't have that personal representative or if that period's closed, then it's going to be the surviving spouse, any child of the decedent. But if there is no surviving spouse or children, then it would be the parents. So you would have some mechanism in place to sort of confirm whether or not this person is considered a representative of the decedent. And then if they are, they would get access rights to that private data on the deceased individual. Hope that helps.
Okay, our next question here, can you speak a bit about the requirement of data inventory under 13.025? How detailed do these need to be? There's not a lot of specific guidance in the law. There is a little bit of guidance in the administrative rules regarding the data inventory, but I think maybe the best resource that you can find related to the data inventory is actually on our website. If you go to the website and go to our policies page, which is under rule, like you go to data practices, rules and requirements, and then our policies page, we do have an example data inventory on that page that might be helpful to review. In there, what we basically have done in that example inventory is have the name of the record, file, the process, the form, or the data type, a description that's generally understandable to the public, so some plain language description, the classification of the data, and then also the citation for that classification. Also on that example inventory, we do include who has access to those data, the employee work access to those data, and that's just helpful as part of the security procedures to let folks know whether or not they certain employees have access to those data. So that's probably the best resource to take a look at to see what should be included in there and maybe the level of detail that you might want to include in that inventory.
I'll just hop in. We received a follow-up question regarding that data on the decedent that I just talked about under Minnesota Statutes 13.10, and the question just disappeared from my screen. I apologize. Okay, if there are multiple living children, can any child request private data on the decedent? It's a good question. The language in 13.10, when it talks about who is considered a representative of the decedent, says that it's the surviving spouse and any child of the decedent. So I do think if there's multiple children here, any of those children would be considered a representative of the decedent and have access rights to that private data on the decedent.
I do want to quickly note here that I have opened the poll, so if you can go ahead and fill that out and let us know how we did today, that would be helpful. Thank you.
I think we have time for one more, and let me just click it so you can see it. Can public personnel data be withheld when there is an active criminal investigation per 1382 when the 1343 data relate to the investigation? I would say no, that once data are public personnel data, they are public even if they're being used in another investigation, a criminal investigation under 1382, they cannot be withheld under 13.43. So once it's public personnel data, it's public. I think we can look at the Harlow v. DHS case for how that works, where one entity might have data in two different places and are using it for two different reasons. So once public personnel data are public, they are public even if they're being used in a criminal investigation.
Okay, yeah, and so that brings us to time today. So thanks for attending and sending in your questions. If you did submit a question and we didn't get to it, do not fret. We will certainly try and follow up with you and answer the questions that you had. We will reach out to you on those questions. I do want to just mention that everyone should stay tuned for a Gov delivery notice for our upcoming workshops and webinars. We are planning an upcoming series of webinars about Section 13.43 and government personnel data. Additionally, we'll be scheduling half-day and full-day workshops once again starting in September. So if you're not already signed up for our newsletter, I would encourage you to do so on our website. That way you can receive information on new webinars and workshops as they are available. With that wraps for today. Thank you for joining us and have a great day.